your contracts what suck.
Suck.
They suck. They do suck. So we are so thankful that you are catching this. If you're watching the replay, thank you for watching the replay. But if you're here live, we would love to know where you are checking in from if you're catching us. So go ahead and drop where you are checking in from in the comments. We should be able to see it and then we'll go from there. But if you don't know, my name is Naquosha Anderson, and I am the managing partner and founder of Anderson Law Firm. And I am here today with my beautiful friend. Go ahead, Danya, tell them who you are.
Thank you, Nikwosha. So my name is Dania Shakfe, and I'm coming in from the Chicago area in Illinois. And we are both contract attorneys, or we do that space. And so I want to thank Nikwosha for uh, uh, collaborating with me today on why your contracts suck.
Yes, your contracts suck, and we want them to not suck. So let's get into a little bit about who we are. We just did, and then now we're going to talk to you about the agenda. So there are a few key topics. We won't be able to get through all of them because it's just too many. It's too many. But we wanted to go over a few things, talking about invisible contracts. We're going to talk about the type of contracts, length of contracts, and how your actions they kind of speak louder than words. And no, this is not marital counseling, but we just wanted you to know that your actions speak louder than words in contracts land too. And then lastly, Dania is going to round us out by saying you set the standard. So let's go into our first topic. And if we have time, we may do a bonus. We won't tell you what the bonus is just yet, but that's only if we have time. So let's go into the first topic, invisible contracts. Dan, you want to talk about those?
Yeah, thanks. So we kind of coined this term, invisible contracts or ghost contracts, but we're talking about the oral contracts. A lot of people say, or you know, people like to come and say, oh, if I don't put it in writing, I'm protecting myself. Like there's that kind of mentality. I think sometimes people, they're trying to do business, and since they're trying to move so quickly, and they uh, like think it's not too important to have a contract, or it's like, oh, like we're best friends and we've known each other since we were kids, but it's really important to put what the parties agree to, like in writing. And the reason for that, or actually like the few reasons for that, is one, like you want to make sure that there's no he said she said. Like Nikosha had talked about, like, this is not marriage counseling, but like when it comes to business, it's actually pretty similar. um, People do go into he said she said. Oh, I thought that you were going to pay me this much. No, I was going to do this. And so I mean, as a practical matter, you want to put the agreement in writing. And so that will also lead to more certainty, and it will decrease the chances of a lawsuit, because a lot of lawsuits are just because of a misunderstanding. And why do you want to spend tens of thousands or hundreds of thousands of dollars just because of a misunderstanding? That also really sucks. And then even if you do go to court, having a written contract, that contract is or it's also a evidence by itself, so that you can actually point to a document and said, so and so said that they were going to do this. Here's their signature. They did not do this. Or so and so said that prior to buying this house, it was repainted in the past year, but it was not painted in the past year, and so that could lead to a claim of fraud, for example. And so that's why it's really important to have everything in writing, again, as a practical matter. And also, if you end up in court, you have something to hold on to instead of trying to go the he said, she said route. So that's why it's really important to not rely on these ghost contracts. So, and so that's not what I have to say about the ghost contracts.
All right. So let's not make sure it's not Halloween, it's not October, and we don't want to see no ghosts. And even if they say their name is Casper, we don't want them around us because they're not friendly. So just keep that in mind. If someone tells you you want to just do something and there's no agreement, Casper the Friendly Ghost says no, no ghost contracts. All right. So, but if you do have a contract, is it really a contract? And what kind of contracts are those? So, we're now going to move into the types of contract, okay? Types of contract. So, what are those? Those could be services agreements, independent contractor agreements, shareholder agreements, equity agreements, licensing agreements. Many of you are out here creating many great assets, and other people want to use those assets. So, you're giving them permission to do it with, of course, money in return. Don't you be out here letting people use your stuff for free. Don't you do that, because that can dilute your rights in a whole other way. But that's not the topic for today, but that was a freebie. So there are also manufacturing agreements. Let's say you actually have products and services. We want you to make sure you're knowing the contract you're entering. So that leads me to talk about, make sure the agreement you have is the right contract, because so many of you are going out here on Al Gore's internet typing contract template because you don't want to pay someone like me or someone like Danya. You don't want to pay us. So if that's the case, you go on Google and guess what? You may be using the wrong template. More likely than not, that template will not help you address all the things you need to address with the other person that you are contracting with. You want to make sure that that template addresses what you need. For instance, if you are a limited liability company and you come to me or you come to Danya and you say, "Oh, I want to share, I want to sell my shares. I want to give you some shares. Here's our agreement." And we look at the agreement and it's talking about a shareholder agreement. I'm sorry, my friend. That is not the right contract for what you need. If you are a limited liability company, you have memberships, you have interests, you don't have shares, you have percentages of ownership, not necessarily shares of ownership. So, this is a great example for knowing you when Google goes wrong. Google won't even tell you that you're using the wrong contract, but a licensed professional will. Another thing that I see in the template world to knowing people that they're using the right contract is jurisdiction. Oh, that's a big word, Nicosia. What exactly is jurisdiction? Jurisdiction just means where you live. Jurisdiction just means where your transaction is doing the business. Jurisdiction just simply means where you live and where the other person resides. All right. And hopefully it's where the money resides. Like our
Oh,
Darrell
yes.
said, where the money reside, where the money reside. Okay. We want to make sure you're in the proper jurisdiction and your agreement, your written agreement that is signed by both parties needs to make sure that that's clear. So let's say you live in Florida like I do, and the person you're contracting with is in Illinois, Chi Town. Hello, Chi City, where Danya is. And if that's the case, if something goes wrong, who has jurisdiction? Is it in Florida where I live, where I don't get no snow? Or is it up there where all the snow is? We need to make sure we understand where we're going to have the disagreement if we have to get to that point. Your agreement should outline this. I know when you come together and it's all sunny skies, you're all excited, but these things need to be included. All right. So that's some things you need to know what type of contract and make sure you're using the proper language for the contract. Okay. So that, I think that's a pretty good idea about
It
types of
is.
contracts.
Yeah, I see that a lot where people come to me with the templates and it's just the wrong template and there's not much you can do at that
Nope.
point. Have them sign a new contract when they're already in cahoots and trying and fighting. It's just it really limits the options of the parties, unfortunately. So it's got like these agreements are like prenups, but for business owners, and they're equally as important. So I'm going to talk a little bit too about the length of contracts. I get so many people who come to say, Dania, I want a simple contract. Don't make this complicated.
Mm.
And I interpret that honestly, the person like doesn't, like they're just trying to look for something cheap. And
I
that's how
agree.
that's how it is. But it's like, listen, I mean, you have like an international manufacturing agreement. There's nothing simple about that. I cannot make that simple. If I
Mm.
tried, it might be malpractice. Like, there are certain things you got to take seriously. Like,
Yeah.
what's going to be missing from your simple contracts?
A lot.
Like warranties, representations. And it's not that we're trying to make things complicated. It's because we know when things go wrong and why they go wrong and how to protect you from that. Because if you wanted a simple contract, then you could just write it yourself, honestly. And that's fine, I mean, but it's a huge risk. So what is missing from a short contract? If you want to keep it simple and short, things that you might be missing, or you want to really make sure that you include it in your contract, is the warranties, meaning what are the promises that the party is making about the product, right? So, like when you buy a car, you have the warranties. I hope that the car manufacturer did not say, listen, my lawyer drafted a really simple contract, so I'm not going to give you any warranties because we wanted to keep this simple. You're like,
Whoosh.
I'm not buying your car because you're not giving
No,
me any warranties, right? And same
exactly,
thing.
exactly.
Also, and the representations, that's also going to be missing from a very short contract. What are the representations? Well, I'm going to represent if I'm a lawyer, my representation is that I am properly licensed and I went to law school, and if it turns out that that's not the case, then, that's fraud. And so, I'm like in a really big deal. You want to be clear about what the parties are, promising about themselves and their skills and their abilities, and the limitations of liabilities. So, like, let's just say there is a lawsuit, there is a dispute. You want to be able to cap your liabilities, and so sometimes people put an actual number, sometimes they put insurance caps, sometimes it's the value of the product, but you don't want it to turn into a free for all if there's ever a dispute, and you're gonna tank your own business if you're not careful about that. And I'm sure you know. Uh, Nikosha can appreciate contracts with clear intellectual property rights. As a
Yes,
trademark attorney,
yes, it's
you
very
have
frustrating.
two like business partners, and you have a trademark or a patent. Who owns the patent and the trademark? That needs to be very, very clear. Is it the company? Is it the individual owner? And then if the owner brought it in, like, do they get their certain rights? If they, for example, if they brought the patent prior to like joining the business, like who owns what, right? And this is one of the most highly litigated, you know, I mean, people are always fighting about intellectual property. I mean, it's very expensive. Um,
Extremely expensive.
yeah, and another question knows this. It is very. I mean, yeah, it's terrible, and it could just be solved with and not a very complicated contract.
It's not something that's complicated to do as you
Yeah,
outlined, but the value of having it speaks for itself. Like you said,
exactly. Yeah,
contracts speak for themselves. It's better to have them than not have them. I think that
exactly.
that whole I want a simple contract, as soon as you start saying you want a simple contract, that lets me know that your high, your risk tolerance is very high.
Yes, that's definitely that's definitely a way of looking at it. Um, yeah, but that's what you're going to be missing. And I'm not saying that a contract needs to be long or complicated, but you just want to not shoot yourself in the foot by trying to have something short for the sake of it. Like, you want to make sure. I mean, that you have these things. And also, I think that what a lot of business owners miss is that when you have a shorter or a simple contract, is that you are going to skimp out on the negotiation process.
Ooh.
I really like to see that contracts are not just words on a paper, it's a strategy. And if you
Oh
don't
yeah.
take that part seriously, then you are not going to be able to sit down with the other party or business partners and say, well, how about we talk about XYZ before we spend a lot of time and money? And so that process helps build the contract. And so that's something that's really, I think, overlooked, especially nowadays. Like, people want to do sales quickly and they don't want to miss out, which I can totally, understand that. But you don't want to have that sale come back to you in a year and you say, oh man, you don't want to regret it. That's the worst feeling for sure. So
It's very
that's my spiel
frustrating.
on simple contracts. Is that you want to make sure that you don't miss out on something that's very important.
There is no such thing as a simple anything. There is no such thing as, if you use the word simple and contract, just toss the water out with the baby. Like
Yeah.
whatever. Wait, I said that backwards. Toss the baby out with the water.
Just throw the
Whatever.
whole thing out, the
Just
whole
throw it
basin out.
out. I don't even care anymore because it, to me, you're just like I threw those actions. The same thing applies when you are in contract, right? You've thrown something out the water, but let's just say the contract actually said that you can't throw the.
Okay, looks like we're having some technical difficulties, but I think what Nikosha is trying to say is that actions speak louder than words, meaning that the words on the paper in the contract are only half of the equation. You have to know how to use the contract. And here's what I mean is that if you agree to something and then you put it on paper and then the parties start to do something else and then there's a dispute, the courts can actually see the actions that contradict the contract as evidence that the contract has changed. So I'm going to give a very simple example is that if you have to pay rent, right, and you're supposed to pay on the first of every
Can you,
month,
can you
and
hear me?
yes,
Oh,
I
there
was
I
just
am.
taking over the actions speak louder than words, but you're back. Yeah,
No,
so
please.
so yeah, so it's like basically like for example, if like your contract says that you have to pay your rent on the first of every month and then you pay on the fifth of every month and the landlord accepts that and does not penalize you even though the contract has a penalty for that, and then the landlord wants to sue you later on for paying late every month, well you can say, well, I've been paying on the fourth or whatever on the date after the first, and the landlord did not say anything. That and the landlord had no problem with it. Why are they coming after me now? So you have to be very careful to like you can't just go back to the contract and say, well, yeah, but it says this because your actions can actually have an impact on the contract. And like another example too is confidentiality clauses. If you don't treat your information as confidential, but you want other people to treat your information as confidential, the courts will actually take that into account, like in certain types of cases. So if you have like a customer list and you are a business partner and you leave your customer list all over the place for everybody to see, and then you want to come and like you want to try to hold someone else accountable for stealing the customer list. Well, the courts are going to say if you don't treat that information as confidential, why should we? So it's very important that you have good counsel to actually explain to you how your impact, or excuse me, like how your actions can actually impact your contract.
Most
So
definitely. Most definitely. I appreciate everybody's patience. It looks as though my area is having a power outage and it triggered my alarm and all these things to go off as I. So thank you all. But Danya is completely correct. Your actions speak louder than words. And so the court system will always look to how you are performing with the other person in addition to what the contract says. So I think that example of having a person pay rent if it's due on the first, but you pay by the fifth, and the landlord doesn't complain, and that has been the issue. And then they try to evict you, and they say to you, "Oh, well, they were also late, so here's all these late fees that they should pay me." Then that becomes an issue. So I really like that example. And I actually had a situation with a client that faced that type of dilemma where um, I had that dilemma where the client was told that they had a grace period, but then when it came to eviction proceedings, the landlord tried to tack on additional rents and fees. So it was definitely an issue. So this is why it's always important to have a written agreement with leases, product purchasing, all of these types of things, because we can go back to what does the agreement say.
awesome. Thank you.
Mhm.
Um, yeah, and then the last thing we want to talk about is the like standard contracts or boilerplates. We get this a lot too. So common phrases I hear are Yeah, just sign this. It's all standard. Or this is just a boilerplate. Or Dania, can you just get a contract that's just boilerplate? So, what do these terms even mean? So, standard contract, first of all, there's really no such thing as a standard contract. Now, some industries might have norms or common practices, but I've reviewed many confidentiality agreements and I have yet to see two that are the same. And I mean, and like it's only like these contracts can only go so many ways. But despite that, I have yet to see two that are the same. And then also along the similar lines is like the boilerplates. So that just means common verbiage. It's really amongst lawyers, and so I could find a boilerplate, but I have to interpret that clause or that boilerplate as an attorney, and I usually change them based on the situation. But it's not really something that means that it's all the same. I mean, it's just not a thing that you're gonna find. I mean, you can find a boilerplate that has 1,000 versions that are trying to say the same thing. And so, how do you know, which one to apply? And also, back to the standard contracts, I feel like when people say, if you just want to sign this, it's standard, means that you have no power to ask for excuse me, to ask for what you want, or if you want to negotiate, you can negotiate because it's not really a standard. You can do whatever you want. Like, so if someone comes to your house and they want to provide a service and they say just sign, it's standard, you can say, hold on, I actually want to read this and I want to make sure it's something that I actually agree to. You can't just tell me it's standard and I'm supposed to just sign, because it still has an impact. If there's a dispute, you end up in court, it's not like you can actually go and defend yourself and say, well, I signed it because it's standard. No, you still have a choice and you can still actually negotiate. So to be clear, like, you can set the standard, and if the parties don't agree, then they don't agree. But don't ever feel like you have to have a certain type of contract or that you have to sign just because it's quote unquote standard. And so, I mean, so like, really takeaway is to not skimp on the process of negotiation. So
Most
that's
definitely, because if they walking over you with this, what else are they gonna walk over you with while you enter the agreement and you start performing your part of the agreement? You want to make sure you are clear and everybody is on the same page for sure. For sure. You
100%.
set the standard. So I think we've been here for a little over 20 minutes and we dedicated some time. So I think they should get the bonus. What about you? What do you think?
Yeah, I agree. Bonus negotiation tips. We keep talking about negotiation. So, how do we negotiate? So there are three key points here on negotiation. First of all, planning. So, so prior to going to to the table, know what you need and what is a deal breaker for you and what is not. And it might sound simple, but it's actually not. I mean, it's really helpful to actually just like sit down and to actually like write it down on a paper. How much am I? How much can I pay? What is most important to me? Is time the most important to me? Like, is it the money? Is it my reputation? What are the things that I am not willing to negotiate, and what I can actually offer to the other side? So don't underestimate that planning phase. And then also to be clear about your goals to yourself. Like, why am I going into this business deal? Am I going into it because I want to grow my business, because I want to free up my time? And like, if you know that uh, 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 you know going in, then if the other side presents something that's not what you need, then it's more easy to walk away. So having those standards and sticking to those standards, not like getting lost in, like all the bells and whistles and all of that. It's just like, okay, is this going to achieve my goal? And also, the third point is to know your numbers and risks. How much is this going to cost you to go into a deal? But also, how much is it going to cost you if you don't? So if I buy a business, yes, it might cost me X amount of money, but if I don't buy the business, then I could lose that on or like a certain share of the market.
Most
Um,
definitely.
yeah,
Mhm.
so you have to look at it both ways. So those are my tips. I don't know, Nikosha, if you want to add any tips.
I would say, don't you gotta know when to hold them, and you gotta know when to fold them. Like, you gotta know. You gotta know, going into it, is it really worth your time, energy, and resources to go back and forth over something that's very small? Like you said, Danya, you have to know how much money, what are your resources, what are you putting up, what are you putting at risk? When you negotiate, you know what your black bottom line number is. Make sure the person who's negotiating on your behalf also knows that and knows what you are holding in extreme importance. If it's for you to, if you're negotiating um, a commercial lease, is it important for you to be able to break the lease because you know that your business may have to move? So that's important to you. Is it that you are talking to a graphic artist and it's important for you to have 3 rounds of revisions and they're saying you only can have one? Is it, I need to buy some materials for my manufacturing process, and they're saying that they can only source it from China, but your mission is to ethically source from US based companies? These are all things that you have to factor in when you enter the negotiation table. And that could be different depending on who you serve and what type of business you have. So just know what those things are, what your goals are, and what's not going to move you and what will move you, and you'll go a lot further. But also have empathy. And when I say empathy, that doesn't mean sympathy. Sympathy and empathy are two different things. Empathy means I can understand the emotions that you are relating to me and I can process them and understand what they are. Sympathy is I am conveying that what you're going through is very sad, is very you centered, and empathy is very us centered and meaning have understanding. I may not agree, but I can still have understanding and move accordingly. So, those would be some things that I would kind of highlight for our audience today, and thank everyone for just, of course, just having patience with us. We as we go through, especially my technical difficulties, this is just letting you know that we live in a real world, people,
Yeah.
where things can happen and you have to be able to
Yes.
pivot.
If we haven't learned anything the last 3 years, that's what we got to do. We got to pivot.
Exactamente.
Yeah.
I'm gonna put the lower Danya, I know your QR code is it's showing up backwards for me. Is it showing up backwards for you?
No, it's not. It's not showing up backwards. But if
Okay.
if it's not working, I guess some people are saying that the link isn't appearing. So maybe we can paste it in the chat. I don't know, but I mean it's working for me, but I don't know if it's working for other people. But
The
this
chat
is
is it is working, but the link is a little long, so I'm trying to figure out if I can shorten it a little bit. Let me see if I can shorten
okay.
it. Short the URL so that way it can be a little easier to get to. Let me see if I can make that happen. Yay, I was. Okay, so I'm going to
Yeah.
put the shortened link in the chat, and
So
then
these are going to be
I'm
two
also
guides.
going to put it on the lower screen. All right.
Awesome. So these two guides, you're gonna get like a guide from me and then one from like Nakosha. And for me, if you wanna like a little bit ago, I had talked about the things that you need to have in your contract, and that's what that guide has. And I think Nakosha, if you want to take a second to talk about, oh yes, the questions to ask if you're uh, 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 negotiating a contract, right? So these are free, resources that you can use on a daily basis for your business or even your personal life, because as consumers, we are also signing contracts for people to come service us personally. So feel free to use those as resources and share them as well.
Most definitely. I developed the resource, the 5 questions to ask when you're reviewing or drafting a business contract, because it talks about who, what, when, where, and how. That was my mindset when I drafted it, to make sure that it's in simplistic terms, it's quick questions to ask, and those can be great frameworks for how you read, review, and draft your business contracts.
Awesome. Does anybody have any questions about what we had talked about? We can take a moment. Otherwise, I think that's the we can wrap it up if nobody has any questions.
Yeah, that's okay.
Awesome. I
Let me
guess not.
see.
We'll give them a minute to type.
Yeah. Someone said trying to scan the QR code. Okay, so I fixed. Okay, I call myself replying. Oh, I think I call myself replying, but they may not showed up. So I will let's see, respond to that person on Facebook and make sure that they have what they needed. Just hopefully that link. Please let us know if that link is working or not working, and then we'll make sure you have what you need, um, either now, or make sure I follow up with you.
Yeah.
So, but overall, I appreciate you, Danya, for
Yeah.
allowing me in all my little errors here. I cannot control the power company. I have no idea, of course, on all the days. This is just how it usually works. On all the days when you have something going on, everything goes wrong. So,
Yeah. No, it's all good. I think it all worked out in the end. Thank you again for all those who attended. And we'll also post a link in the event too, if you guys want to check it out later in case it was missed. And otherwise, have a great day, everybody. And don't forget to unsuck your contracts.
yes, get away from sucky contracts. Your contracts suck. Follow our tips so you won't have sucky contracts, okay? It's plain simple. And just like that, we're out. Thank you so much for catching it live, and thank you so much for watching the replay. We'll see you all later on Al Gore's Internet.